everyone. I'm the research manager at DAKSH. Welcome to the launch of our case study titled Technological Transformation of Kerala High Court. Late last year, I had visited the Kerala High Court to get a sense of its digitization efforts. We at DAKSH are very interested in how technology enables improvement in court processes. What I saw at the Kerala High Court really impressed me. At that time, e-filing had been made mandatory in a couple of case types, and there were a few paperless courts set up. The whole process of digitization was not being jerk. It had been well thought out. When I went back to Bangalore, I told my colleagues this. Some of them were a little skeptical and thought I was yet another Malayali who was bragging about the Kerala model. Still, we decided to go ahead and study the process of the digital transformation of the court in detail. We sought permission from the court to do this study. I'm pleased to announce that the case study is finally ready. We've deliberately crafted this in the form of a case study and not a report because we want other courts and students of law and technology to read this case study and understand how to go about the process. It is not just about the results of digitization, but it is the process that is really important. My colleague Anandita and I spent a lot of time here. We made 2 visits. We spoke to a lot of judges, staff, advocates, advocate clerks, etc. And it's their cooperation that has made this possible. Thanks again to all of you for coming on a Thursday evening. We'll start today's proceedings with a short presentation by Anandita and me on the findings of the case study. Anandita?
A very good evening to everyone present here. Thank you for making the time to come and attend this launch, even though India is playing a cricket match today. I'm Anandita, one of the authors of this study, and I'll briefly take you through our observations. I'll begin with the purpose of our study. So we all know that the Supreme Court E-Committee has released a vision document and made a roadmap for how digitization of courts should take place. But the onus of implementing these changes are largely upon each High Court. Even though the infrastructure and technical support comes from central organizations like the NIC, the implementation is happening at a state level. This makes the Kerala model very interesting to us. We were very interested in knowing how exactly, given Kerala's advancement in this field, how they maneuvered a central system to achieve their state level requirements. As researchers, we also found that the inner workings of the registry are a bit of a black box in any High Court, and we thought that this study would help people, including students of law and technology, to understand exactly how a case file is processed. And that should give an idea of the challenges that are presented in digitization. Leah has touched upon our methodology. It was a mixture of desk research, technical resources, a series of interviews, and demonstrations and walkthroughs that the IT team gave us about various features and applications that they developed in-house. So I'll just take you through what we studied, but to understand that, we simplified the life cycle of a case, of a typical case. So there is filing of a document, it undergoes scrutiny, the matter gets listed, there's a hearing, there are some actions that happen depending on what happens in the hearing, finally there's an order, and then the process is repeated. Maybe the other side files a response, another application is filed, etc. And this process continues till there's a final order. So we decided to touch upon 3 main reforms, which at least briefly touch some part of each of these processes. First, we looked at e-filing, which looks at the first stage filing of any case type. Second, we looked at scrutiny. Again, this is a stage where there are several developments for all case types. And finally, we looked at paperless courts, which touch upon the remaining stages, but are limited to certain case types and have not touched all case types. But before that, we actually started with studying the bail model. And why this is because in many ways it seems to be the trigger or the initial point at which digitization really took off in Kerala. So what we gathered was that the plan for reforming the way bail applications are heard was underway even before the pandemic struck. But the pandemic itself acted as a sort of catalyst and further accelerated the processes that were underway. Now, this may not be very clear here, but when you do go through our report, you'll see it in more detail as to what are the various steps that were re-engineered in the bail process. And by this I mean, it's not simply that there was a virtual representation or a replication of the same steps that were happening in bail physically, but certain processes were entirely changed. For instance, scrutiny in bail is now automatic and is done by algorithms without requiring a person playing the role of the episode of file scrutiny officer. But the interesting thing, instead of looking too detailedly at the bail module, what we really took away from it is that it acted as a test run for digitization of a case type. So bail being something that touches upon fundamental rights, but also being something that is format friendly and relatively simple, acted as a great starting ground for seeing how various stages of that file or of that particular case can be digitized. We also noticed one very interesting thing, which is that in the bail module, the High Court is able to communicate with other institutions like prisons or police, etc., and the public prosecutor also. And this is something that was already envisioned in the ICJS, or the Interoperable Criminal Justice System, which some of you might know is a prominent feature of the vision document of the key committee. So we found that the bail module actually gives a sort of a prototype for something like ICJS to work. And even though ICJS is operational to some extent in all states in India, it hasn't reached its full potential. And we felt that maybe the bail module is a way to look at this problem differently. Another important thing about the bail module is that we realized it's the beginning of the CMS. Now, the CMS is one of the most prominent developments in the Kerala High Court and is of particular interest to us. Because the basic digital infrastructure and software for court systems is actually developed by the NIC, and that is the CIS, or Case Information System. But while trying to make the bail module work, we found that the Kerala High Court could not work with CIS. It was not giving it the right kind of flexibility in order to incorporate something like the bail module, which is what made the Kerala High Court develop its own alternative to the CIS, which is the CMS, or Case Management System. So the bail crisis was basically the trigger for this development, and this makes it very interesting for us to study how bottom-up approaches and how homegrown systems can achieve the vision that the E-Committee is trying to achieve. So we go to the first reform that we studied, which is e-filing. Now we have seen many other courts try to adopt e-filing, and we found typically that there is a sort of a replication of the physical process. So typically during the filing stage, there is a scanned version of whatever would have been typed out. And the next time we see that file is at the hearing stage, when again the entire case file which would have been printed would then be scanned and uploaded onto the judge's computer. So you have some sort of digitization at the filing stage and something at the hearing stage. But there are a lot of stages in between where there's a lot of processes that occur within the case file, which is still happening on a paper file in other high courts. In Kerala, however, we found that the spirit of e-filing is better understood, and e-filing is not seen simply as the digital version of a physical application. It's seen as a foundation on which to engineer processes. So like a scrutiny or any other file processing that happens after the hearing, sending of notice, all of these actions can occur within the digital file itself. So the image that I put up on the screen is an example of how the entire file is a virtual file. Not only what a litigant puts into the court system, but what happens within the court system, like the order sheets, the orders, all of this is built within like a complete virtual case file, which allows for process engineering to take place. Then we moved on to the scrutiny section, which also we found to be very novel. We found that there were several changes. Many of you might already know this, but it started with first shifting to a virtual system that had a 3-shift basis. Then it moved to a 2-shift system, and now there is an automatic scrutiny option for bail. Well, we didn't find many people telling us that this virtual scrutiny was reducing the time taken for the case to be listed. But we feel that the aspect of time saving is not the only goal of policy experimentation of this kind. We found that the very fact that there were so many changes to this kind of model, like that fact that it moved from a 3-shift system to a 2-shift system, the fact that there's an algorithm being built at the same time, all happened within the 4 months that we studied this system. So from our first visit, we did find there were complaints that were coming both from the FSOs as well as from the lawyers about the scrutiny system. There were some hitches and glitches in between, but we also saw from our interviews with the computer committee that they already knew about these problems. So clearly communication channels were working. We also happened to see a live consultation process that, where the Advocates Association was taken through what the machine scrutiny of bail would look like. So for us, scrutiny really served as a kind of place where iterative changes were being displayed, a lot of administrative decisions were being made extremely quickly, and that there was a constant feedback loop that we could see. The various stakeholders that we were talking to and getting information from were talking to each other. We could see the same points being reflected from each of the stakeholders. So for us, scrutiny really showed us how it's a great space for incremental change in a small span of time. Finally, we looked at paperless courts, and paperless courts is probably one of the features that we found that advocates were least impressed with. So most of them said that it's not really a paperless court. Everyone uses the paper files. No one's really looking at the computer. We also sat in paperless courts and saw how people were using paperless courts. And to some extent, this was true. But at the same time, we saw several young lawyers, whip out their phones in a paperless court and go through their virtual cases, preparing for cases. So in some sense, I think we missed the point of what the paperless court was, and that's why in our report we believe it's a misnomer and it should be called a prototype digital court. And I'll tell you why. So in the flowchart, if you remember, there was filing scrutiny, but paperless courts doesn't just tackle hearings. What we found was that it tackles listing, hearings, file processing, and orders. So there are many processes that occur behind the scenes which are not really a part of the hearing, which happen differently in a paperless court. For example, listing is automatic in paperless courts. Again, we didn't find that the lawyers we interviewed didn't really tell us that listing happens faster in paperless courts than in paper courts. So the time-saving element may not be evident yet, and we also don't have the data to analyze it. But nonetheless, the fact is that there is some amount of digitization occurring, and people haven't really noticed the difference, which means that it isn't impacting the processing any worse than it was before, at least. There's also a lot of other process re-engineering that's happening behind the scenes, like there are digitally signed orders. And the paperlessness of the court is not limited to the courtroom or the physical space, but it happens in all the case file processes that occur behind the scenes. We also looked at how section offices work in non-paperless courts. We saw how many registers they have to maintain. We saw that they have to physically move case files from the judge's chambers to the section office and so forth. All of which is not required to be done in a paperless court. We saw that the virtual case file, which started with the e-filing, is the backbone of how the processes are happening in a paperless court. So in this sense, paperless courts are a misnomer. The effectiveness we feel has not been adequately conveyed to advocates, and maybe in some time, as these processes start showing significant changes in the time taken to dispose of a case, probably the meaning of paperless courts, or rather the prototype digital court, which is also imagined in the vision document, might become more evident. Now these were the reforms that we studied, but from all three of the technologically enabled reforms, we gained some insight into what worked in Kerala High Court, which may or may not be there in other states, what is peculiar to this state. We also found that there were some gaps and some challenges, and where work is required to go forward. And now I invite Leah to share some of those insights with you.
So these were some of the strategies that have led to the success of the digitization efforts at the Kerala High Court. The first one that we identified is extensive mapping of existing processes. Now, Anandita has touched upon the importance of process re-engineering. In order to re-engineer processes, you first have to understand the existing processes. And we found that when we spoke to a lot of the staff, they knew what their role in the larger system is, but they didn't know what anybody else was doing. So it was very important for the IT directorate, which had been newly set up, to actually map the existing processes. And then they were able to identify redundancies and go ahead with the re-engineering process. The second strategy was phased implementation. Now, digitization of code systems, as you can all imagine, is a mammoth task. On day one, it is very difficult to envisage what your end product is going to look like. This is such a radical transformation of a very old system, very old, very bureaucratic system. So it's very important to go about it in a phased manner. And this is what we saw at the Kerala High Court. So even for e-filing, they began with certain case types, paperless courts. Again, certain courtrooms were converted into paperless courts. The machine scrutiny of applications is right now only for bail. So in this way, a phased implementation allows you to seek feedback, incorporate the feedback, improve the system. This kind of an iterative approach is very important. Active support and training. This is again something that was very obvious to us. The changes in the CMS were not just imposed on the various stakeholders like lawyers and clerks. The computer committee and the IT team made a lot of effort to reach out to them, organize trainings, have helplines. There is a WhatsApp helpline, and Ishaq, who's the head IT team, he's always on that WhatsApp group addressing grievances. So this is very important, to have a very robust grievance redressal system and to incorporate the feedback that the users are giving. Incentivizing use of technology. Again, this is very important when you're changing processes. You have to make the technology work for the users. It shouldn't make their life more difficult. You have to incentivize it by making their life easier. So a good example of this is the machine scrutiny of bail applications. So if a lawyer chooses machine scrutiny, the scrutiny gets done in a matter of minutes rather than a day or something, which the manual process would take. So that really incentivizes the adoption of technology. What were the supporting factors? So we just covered the strategies of the High Court. It's important also to understand what are the factors that helped realize this vision in the Kerala High Court. First and foremost, of course, leadership and staff. At DAKSH, we do a lot of work on technology, and we never underestimate the role of people. People are really important. The tools, the technology, all that is secondary, and we saw that in the Kerala High Court. Whether it's the computer committee, the IT directorate, the IT team, these are all very dedicated people, really committed to the digital transformation of the Kerala High Court. And you can see the pride they have in their work. And as I had said, they keep communication channels open and seek feedback wherever necessary. Secondly, the state government. So the state government is very important because they are the ones who provide funding for such initiatives. Most of the funding under the e-courts project goes for the district judiciary. So any kind of technological transformation of the high courts do require financial support from the state government, and that again was forthcoming in Kerala. The Advocates Association. So during our study, we had a lot of interaction with the Advocates Association, and we saw again that unlike in other states, there isn't an adversarial relationship between the judiciary and the Advocates Association. There are consultations with them, their feedback is taken and incorporated to make changes in the system. That being said, of course, there are still some challenges, and that is, of course, also a function of time. It's only been, I would say, a couple of years since these processes were implemented, so there is some way to go. These are a few other areas that we have identified. First is courts as a technology-friendly space. By this we mean that this is also again a function of time and the generation of lawyers and judges. So we see that a lot of judges and lawyers are still comfortable with carrying paper bundles, with flipping through case files, and we think that is a matter of time. As new generations enter the bar and become judges, this will change, they will be more comfortable with technology. The digitization of sections. This is something Nandita has touched on. So right now, apart from the paperless courts, the digitization is mainly for e-filing and scrutiny. The sections are still, some of them still look like, pre-digitization. There are stacks of files and people are still making notes and registers. So we think that till the old pending matters are digitized, maybe it's going to be difficult for sections to get digitized, but this is definitely a challenge currently. Procedural justice, this is something that all of us need to keep in mind, especially legal professionals, that in the process of digitization, we should make sure that the levels of fairness and procedural justice that we have are not compromised. Data transparency and digital public infrastructure. So currently the CMS as it exists is a vast, very efficient ERP system. It's still not built like digital public infrastructure, so we do hope that the Kerala High Court does move towards that, so that researchers like us can have API access to data. If we are able to analyze data, we can understand, the transformation much better, especially the impact on movement of cases. Intelligent scheduling. So within paperless courts, you do have automatic scheduling, but it's still not intelligent scheduling. And from our work across courts in India, we see that listing is a big problem. So we think that if we have algorithms that can help with intelligent scheduling, that would really help with the pendency problem. To end, what we found is that the approach of the Kerala High Court has been what we call decentralized policy experimentation. So the way the e-courts project has been implemented so far has been top down. The policy is created in Delhi at the Supreme Court, and everybody else just implements it. But we found that what we call the Kerala model of judicial reforms now, which is a bottoms-up approach where the High Court takes charge. And the main users of the technology, who are the judges, the lawyers, they are much more involved in co-creating the technology. That is we think, is a much better process for digital transformation of courts. Thank you. We'll now move to the much-awaited panel discussion. I'll just introduce our panelists. Justice Mustaque has been a permanent judge of the Kerala High Court since 2016 and chairman of the Computer Committee of the High Court since 2019. While practicing, he served as standing counsel for Hon'ble University. He's appeared for several education institutions, telecom companies, and local authorities. Justice Vijayaraghvan was sworn as an additional judge of the Kerala High Court in 2015. He was appointed as a permanent judge with effect from 2017. He has practiced before the district and subordinate courts at Kollam and thereafter before the High Court of Kerala. Our third panelist, Santhosh Mathew, is an advocate of the Kerala High Court. He is a graduate of the National Law School of India, University, Bangalore. His practice areas include writ petitions, media law, environmental law, education law, banking law, company law, and service law. Dr. Asharaf is a computer engineer with extensive exposure in algorithms for machine learning. In addition to his current role as professor in the Kerala Digital University, he is also visiting faculty for the MDP programs in Indian Institute of Management, Kozhikode. He has received his PhD and Masters of Engineering degrees in Computer Science from IISc Bangalore. The discussion will be moderated by Surya Prakash BS, the Program Director of DAKSH. I invite all the panelists to the stage.
Thank you, everybody. Thank you, Justice Mustaque, Vijayaraghvan, Santhosh, Mathew, and Dr. Asharaf. First of all, I want to congratulate you on a fantastic project that you have handled. Completely hats off to you. This is a great initiative. Hats off to you and your team for the initiative and the enthusiasm and the energy. And the way you structure this panel discussion is probably, take one round of opening comments from each of you, and we'll come back for a deeper dive. We have some technical questions, but I want to start off with really understanding, something like this. When you're going to go off the beaten track, right? You are not willing to accept the status quo. What was your motivation? What prompted you to say, this is no longer good enough for me? Right? I just want to go behind that mindset one before we dive into the technical details.
Thank you, Surya. In fact, it is better I take you to the starting point of our initiative. In fact, the key committees chalked out the program as early as in 2006. We are now almost 70 years. As you know that nothing is visible except information developed at National Grid. When Justice Navneet Prasad became the Chief Justice of Kerala High Court, he made a comment. Hitherto he was under the impression that the most backward state in IT infrastructure was Bihar. But after coming to Kerala, he realized the most backward state in IT infrastructure, Kerala. Even I became a judge in 2014. I was not aware of the existing committee called Computer Committee. I realized in somewhere in 2017 there existed a committee. You just imagine the situation in Kerala. Of course, they meet, they try to implement some of the direction from the committee. Beyond that is nothing is happening. There's nothing happening there. Raja was part of the committee, being an engineer by profession and a lawyer. He was there in the committee. So when I entered into the committee somewhere in 2018, 17 or 18, because I actually happened to be in that committee because I made a presentation in Judicial Academy in the regional conference. Then Navneet Prasad seeing me that presentation, even I was not aware there is such committee. He inducted me. That means 2017 I came to know about the committee. I was inducted. I have no idea what is happening. Every time we have whatever snacks that will go and whatever the NAC people said, we will accept. But I said there is a lot of diffidency from the side of Raja and Justice Suresh Kumar. They always try to question me, but they are not able to get answers. They are not satisfied. All that. There is a lot of discontent. They are not happy with what was going on. Then suddenly I became the chairman in 2019. When starting, of course, opportunity came by the way of COVID, thanks to the COVID. Because of COVID, we are in a such situation. So all that has happened in Kerala, it was only 4 years old. We have only started. I must say, we have only started. Long way for us to go. Maybe when you're comparing with many other high courts, you might see that Kerala is topmost. Kerala is well ahead of the time with others. But that is different. It's only based on the comparison, but Kerala only began its journey. So that journey has been only 3-4 years, and we have a long way to go. When I saw the presentation, the challenges, and paperless code is not a paperless code. Yes, we accept that it's not a paperless code because we are yet to digitize 250,000 files. We have to be digitized. Secondly, there is no business process engineering. A lot of things is coming, of course, that will share later. And we working with the 5 IT professionals. We might have spent only 3 crores last as a salary, whereas in all India level, we might have gone up to 200 crores. But they are not achieved anything, but we have achieved the best application at least. That's what we can only claim. We have best application with us. So it's for us a long way to go, and it's only starting point. So don't anyone have an impression that we have achieved everything and nothing is visible. Visibility will come later on as far as the litigant and others who are in the institution from outside. But those who are within the system, of course, they may feel that something is happening.
This is Mustaque has just about said everything, but since you asked about how it all started, sometime when this Dominic was there, we were flustered about the functioning of the system. We wanted a lot of things to be done. We wanted a mail application to be, streamlined. Record should come from the police and everything. Nothing was happening. We tried our level best to pursue it. The entrenched NIC people out here to do something about it. So we understood that there's some sort of an agreement between the Supreme Court, the NIC as well as the High Courts, and as to which the NIC people were supposed to do everything. So fortunately or unfortunately, no High Courts in the country have set up their own IT infrastructure. They have never had one particular individual, even in the High Court, to look after their own management. We understood that the CIS, what they call as a case information system, it's not for the court management. We asked them, can we do something about it? Can we file an application? Can we digitize it? Can we, start e-filing? They come up with sort of excuses because whether you like it or not, what they have is a monolithic platform, which is, they envisaged sometime in the year 2005. So it's a core and periphery module, and we understood after deliberations that absolutely nothing of this sort that we have developed here can be achieved using that module. So we requested the state government. We asked the finance secretary, the chief secretary, etc. to come here. We persuaded them to request a person who is well versed in technology to do an audit, whether we are going in the right path. They asked, I think it was Mr. Santhosh, who is an IAS officer. He is an IIT computer science person from Chennai. He conducted an audit. He said he gave a scathing report that this is absolutely, we are moving. Then what we did was, we requested the state government to fork out some more funds because NIC people, what they do is, I'm not supposed to say this, but I have to. They get a, very, very unqualified person spending 15,000 rupees and they're trying to put up things. So we requested the state government do one thing, please give us some salary. We need to pay at least 1 lakh or 1,25,000 rupees if we want to get a good professional. They agreed. They agreed to pay close to 1 lakh rupees for hiring on contract basis tech people. We did an interview we got people from outside. Unlike normally what we do is, judges themselves, we got 2 of the best persons in the state to come here. I was also there in the interview. We got the best 5 persons. Ishaq was there. And then, we started on this. Every single location, we requested this module, that module. They did a study for about 6 or 8 months to understand whatever the domain knowledge required. Nobody can do it because unlike, you ask a TCS to do it, we requested TCS people also to come here. They visited the High Court, they did not do it. So, unless every individual who sits here, the persons ran around, they interacted with all the persons in the registry, advocates, clerks, all of the judges, and they started from scratch, from bottom up. We had absolutely nothing in front. No, they come from Karnataka and Maharashtra. With the think tank policy, all those things. They have prepared a vision document several years back for the E-Committee and everything. No other High Court, let me tell you, no other High Court in India has anything that we have. Karnataka has nothing. Andhra Pradesh has nothing. Tamil Nadu has nothing. What Delhi people have is they put a thing in the folder. The judge sits on there, there will be 3 or 4 folders. They will sit and open the folder. If an additional document is filed, somebody, 140 people are sitting in the back and they just put the file on the folder. Nobody else except Kerala has this court management systems which we have now. Brick by brick, like in the Lego brick type, we built it up from scratch. We requested all the people, the IT director is there, Sarina was there, Rajesh is there, we got all these people to stick around for this long. And unlike, when Leah says about, applications and everything, this is not how it is done. We obtained inputs, we did, when we started on the bail application module prior to the COVID, sending email, how many excuses. Mustaque was sitting late in the night, till 2 o'clock. Even now Mustaque is in the group. Every judge is also interacting with every person, every opinions of clerks and advocates and so on. We started from the brick, the lowest brick onwards. Nothing in front, nothing in back. This is just something which we've developed, our kids have developed. And I don't know whether these people have gone around. I used to tell India when they used to come earlier, why didn't you do an audit in respect of Karnataka or the Supreme Court? They have not done that. They should have called it out. Why do you are the tech capital of the country? Why don't your courts have some sort of a system? They haven't done it. They come to Kerala, you should be proud because these people are coming to Kerala because we have a good thing going. Nobody else. Nobody else. And unless you people, you gave us, I remember Sangeeta speaking about all these things a couple of years back. A lot of people have said good things about our system. You said when a lot of people came out against this, like digitization and everything. The things that we have in mind, if AI and blockchain and large language model and everything comes up, even other countries don't have it. I had an occasion to interact with a UK judge. Chima Gurb, she was in the National Judicial Academy. I showed her, dashboard and everything. She said, I am jealous. US judges don't have it. Like a dashboard that we have for the judges out here. Nobody has it. There are some things, our dashboard may not work like an iPad, but the thing is, this is better than everything out there. Better than everything out there, and a lot of work have gone into this. You should, the central government is earmarking 264 crores to develop a software for this thing, for all the high courts. Just imagine, 264 crores. Like Mustaque said, we spend 1,50,000 crores, 1.5 crores, or 150 lakhs for this thing. Just imagine. Nobody else has anything like this. It's not, all the high courts, they just open a PDF file and that is their paperless. None of the high courts have interoperable module. I can see the document file by all and sundry. Nobody else has. So we should, be happy that Vijay has come here. DAKSH has come here. Vijay is also there. Vijay is sitting on the back side. Adami is here. Ukar is here. Everybody wants something to do with the book. So,
I just wanted to say those emotional outbursts, and just clarify, NIC might be NASA, but our committee is ISR. And this is a Chandrayaan in the legal fraternity because with our limited resources we have done. I am not saying this to praise the gentleman sitting here, but there has been a lot of criticism when we try to change. I think lawyers also need to adopt to changes. We have to take care of the clerks. There is a lot of challenges in implementation, but at the same time, we have to change ourselves. And this being a Thursday when Leo the movie was released today. From the lawyer's point of view, we had a young Leo assisting a lot of lawyers in getting up to speed regarding the usage of these particular changes that is happening. So I think we are a step in the right direction. A lot of things needs to be done, but we have to appreciate our judges and the committee for doing what it has done.
So my experience dates back to a few months. I started looking at this system, the CMS system that the Hon'ble High Court utilizes as a part of the consultative work that Digital University does with the Hon'ble High Court. And when I came here, and because I come from a background of scale systems, I mean working with the large web companies of the world, and what I expected was the typical process automated context where I've been involved in many activities where governmental processes get automated. Trivial systems were automated in such a way that all that happens in the conventional systems are brought into the computer as a government judge mentioned. It is primarily around you get a printout through a computer or your file rather than being seen in a paper, you have it in a computer, and that's a trivial methodology. And when I looked at it, I was really surprised to see that it's being architected in a way where service orientation was the primary perspective, and that too a microservice orientation, which is essentially around you look at processes and build it for scalability, efficiency, and then extendability. And this is being done here. It's an excellent platform which has the potential to be developed further for interoperability, and potentially I hope this will become the de facto platform for the national adoption.
Hold on the mic. So maybe we come from that side this time. So Dr. Asharaf, you've seen many sectors like you mentioned, in the state side also. So what do you think of the justice system when you look at it from a technology perspective, as a technology specialist? What excites you? What interests you about this sector? Why is it important for you to be associated with this?
Yeah, I have two words to describe to answer the question. The first being impact. I mean, the impact. Yeah, the impact that such a system can bring onto the table and for the society at large. That's the first answer. And the second answer is scale. Because scale is something that we do require to bring that impact. And what such a system which has a potential to reposition our processes, to relook the way we conduct our business, I think that's where it is.
Right. So impact, scale, and process challenges. Right. So Santhosh, as a user of the system, there are many types of users, and that's a very typical challenge for any large system. How do you cater to the needs of different kinds of users, whether they be age difference or technology friendliness or just bandwidth maybe? So as a user, from your experience with talking to your friends in the lawyer community, how do you think this project has impacted them?
I think my selection has been because I'm a bridge between the old and the young, but I also fall in the category of the technology challenged. So what I have done is I have invested in young minds who are good, who are technologically proficient, who takes care of the filing, and at the same time ensure that our clerks, etc., are also taken care. But on a serious note, I think this has made life easier in terms of filing, but this has pampered lawyers also because in terms of facilities, in terms of comforts, etc., there is a lot of I see a frown on LHH's face because it is not technologically friendly, but I think if you take an effort to learn, it can be an easier way of doing things. But at the same time, I think it is a continuous legal education is possible. It's required. We need to empower, and even the elder generation, I think, while arguing, some of the senior judges, the court officers mirror, and then they can adapt easily. So I think systems can be brought to where the young lawyers sitting with seniors can mirror whatever assistance is required, because now paperless is a misnomer, but I think digitally, I think people will rely on that, but I don't think paper will go, at least in our generation. But I think there could be procedures put in place where younger people could assist their seniors in trying to argue and facilitating the process.
So you're saying that the youngers, who a lot of the community need to take the lead in adoption and ensuring others come up to speed.
Absolutely, because legal literacy, now information is available online. Now challenge of lawyers is to ensure that after updation, the information which is correct needs to be used and applied, because there could be a lot of precedents available online. Now what is not overturned, all those things has to be done, and we have to be up to speed. Now having said that, now because of the availability of data, we can find out what are the other cases filed in this particular subject also. Now, even though presently we are not having access to all the petitions filed, but I think soon will be the day where, like companies, whatever is filed in a registrar of companies is available, being a court of record. I think writ petitions filed by other lawyers also will be accessible in due course. So once that happens, I think with this access of information, it will make lawyers more equipped and it helps in litigation, conducting litigation also, and bringing transparency. Because when orders are uploaded, there is a lot of accountability also happening as far as the clients are concerned. Lawyers can also tell what is happening and they can see for themselves as to what is actually happening in courts.
Got it. So, this is Raju sir. Same question from a designer, because you designed this system, and we are here, like how you rightly said it, DAKSH is really riding on your initiative. We wanted to showcase what you have done to the rest of the country, and that's really why we chose, like how Leah said, we chose Kerala High Court for this. This is the first of it. You like how we have done the first of its kind system. This is the first of its kind study. So when you're designing such a system, how did you think about users' needs, on what they would want, or what are the different kinds of needs that they have?
Now, Santhosh mentioned about one lawyer, that Ms. Lekha, who he said is technologically challenged. The one thing you need to just bear in mind, you go to a appellate court, a federal court judge in the US, he hears 3 cases every week, or 2 cases every month. Here, before me, 150 or 300 cases is close. So what most of the judges find it difficult, because if 40 cases comes up before them in a physical file, it would be easy for them, because reading PDF is not the right thing. Probably those advocates who, I've seen Mr. Datar, I've talked to Datar, he was using liquid text. He can argue a 2,000-page matter without even a scrap of paper. But unfortunately, in our state, nobody is, using all those applications. We can't expect them to use those application tools. So, as far as if a particular counsel has 3 cases, what we expected was that he should come to the court. He should be able to access his files, and he should be able to do his research by sitting the monitor in front. Just as Mustaque was instrumental in putting up a touchscreen monitor in front, he also wanted a rail to come in so that the computer can be shifted, but that didn't happen. But he wanted an interface which was so simple that the moment the case is called, the case should come up and he should be able to peruse the PDF. In case he wants, he can use the keyboard as well as the mouse. He can access the CC and all those things. Insofar as judges is concerned, we, from the first judge onwards to the last technologically challenged judge, we asked them what exactly you want.
So there were actually interactions.
One judge wanted the synopsis alone, or the prior relief alone, or the internal relief that is claimed alone. Other judge wanted the entire PDF to come down. Other judge wanted, he used to prepare a notes in this thing itself. So he wanted in the morning itself, so that a table would come up, the number of cases and whatever he has tried. Just as Anu types everything and she prepares a note and she looks into it. Some judge doesn't want to look into it because everything is in his mind. So we asked all the judges from first to the last as to exactly what they want.
So they were actually,
because the person who designed all the IT, these are district judges, but they don't know how we function. The IT person absolutely unaware as to what goes in the judge's mind. So they sat with Justice Mustaque and all the judges from top to bottom. Justice Alexander said, I want this. Justice Ravi said, I want that. All those people have given their inputs, and it is after getting their inputs, some sort of a dashboard is there, a one-stop dashboard. If you can see the dashboard, they put up a picture there. If you can see the dashboard, everything related to the particular case comes up. All journals, etc., the trajectory of the case, everything is there. Yeah. So it is just just speaking. Today's dashboard may not be there tomorrow. We will change certain things.
Yeah, no, I've heard that. I mean, when Anandita and Leah were doing the study, they said finally we found some point, and the next visit they came, that point was no longer there because it had already been rectified. That kind of fast response.
Because we have a group itself. The judges also, there is a WhatsApp group. We post that particular thing. These people are in that particular group. We give suggestions. So every time, you should understand that prior to the CMS, prior to COVID, it was such a crude version. You have to make the costless generation everything. Now entire thing is automated. So we are just, it's a work in progress. Probably a couple of years from now, we'll have a foolproof iOS 17 system. It will work like Swiggy or Amazon or something. But finances are there. Open source softwares. We can't just we can't do in React Act. A lot of things which are holding us back is there. Data security, protection, safety. All those things are there. We need to take in account all these aspects.
While judges are very important and they kind of help decide whether a system is adopted or not, the design for an end user like lawyer or other litigants are also important. So how is that factored into the whole thinking process?
The design is not architecture. The design is what the vision.
Right.
So even if the big tech people here, they cannot build a platform unless they have the vision. The vision comes with it, not from the outside. This we realized. We realized the people we are engaged, they don't have vision. Though they are here more than 15 years or 20 years. The vision has to come from inside. So our approach is the vision. And that is the design.
The great answer. The great answer.
So in a way we build is not something we know that if we build something and we try to ask them to accept it, it would be like imposing on them. And there will be reactions. The very volatile state like Kerala, very right-oriented states, Kerala, always everything will be accepted with objection or opposition. Maybe the first time in the history of the Kerala, without much opposition, the people have accepted because of our approach. So we build the application not from our perspective, but from the perspective of the user. We ask the judges, we ask the lawyers, we ask the finance scrutiny officer, we ask clerks, including. So the user perspective was of mind. And at the same time, we also have a vision in the sense it should be a virtual office for everyone. One go, one platform. That is our motto. And we are the path of realization of that. But at least we can say that we are beginning the process.
Yeah, that's a nice pivot to, I think, looking ahead and possibly, if I could just request Dr. Asharaf, if you will mind. Because you said a few months back you were acquainted with this software and system. If you were to do it afresh, what would you do different? I have one follow-up question.
Okay. Yeah, that's a difficult question. Now, my answer is architecture, and there's a reason for it. Now the system is architected and from a monolithic CIS kind of a platform to a microservice architecture, which is essentially around process efficiencies. And when we build systems which operate at scale, which is typically they are looked at from a data perspective. So a data-oriented architecture with a data layer and a service on top of it. And I'm sure the current service architecture can easily get graduated to a data-oriented architecture, which is a norm for scalable high-impact systems. And that's my answer.
I think you kind of guessed my second question, so you have answered it already. How can this be made to be a digital public infrastructure, and what was that also hold good? Your answer hold good for that?
Yes. When that needs to be done, typically in production systems, this is done with the help of sandboxes, technology sandboxes. The certain things can be publicized, made accessible for people to access, leverage, and public to have a feel of how things are happening. So this can enable, but there are challenges around it, which is anything that goes within the code system is not meant for completely accessible to the public. There are things that needs to be managed with its own merits. Having said that, if we can anonymize data, if we can detach certain data objects for publishing as in the perspective of public good possible, aggregation, anonymization, and detaching from the production system, probably in a sandbox fashion is the way to go from a data-oriented architecture.
Right. Santhosh, what more do you require?
During COVID, we used to watch foreign language movies where subtitles were shown. This just went above my head, so I did not understand what my friend said. But having said that, I think when my friend became a lawyer, I was thinking, why did he take up law after doing engineering? But I think there is a fate playing out here. I think a lot of people have a purpose, or I firmly believe that God has a design for each person and fate takes you where it is. I think we are in the right direction. I don't think I'm competent to say anything regarding the technological bit, but I think as lawyers we need to introspect and stay relevant if you have to continue the process.
So, a couple of questions before we kind of open it up for questions. And maybe the tougher question, actually, if I could ask this starter, how do you see this system being adopted across Kerala now?
Across Kerala?
Currently it is in the High Court. How do you think it will play out in the district courts of the time?
So, Justice Mustaque has done the sweet work for incorporation of CMS. We are sitting out in the local self-government tribunals and the vigilance courts. That's a trial basis, 3 months. Work of tribunals. Immediately after that, we'll just spread it out, open it out to the district court system. That is what we are planning to do. Lot of, but then there are some policy decisions are there, but then we have in 2019 we sent a letter saying that we want a CMS, please take us out of the CS thing. But now some policies, the central government has earmarked about 7,000 crores for infrastructure development, and certain agreements have been entered into, and as per the agreement, it appears that NIC is supposed to develop the module. So how are we going to, I don't know how we'll face it, but then our plan is, because lawyers who are practicing in the trial court come to us and say, who are there in the High Court also, they will come and say, why are you forcing us to use this system, CIS? That is the problem that we are facing. Once in a month we are having interaction with the lawyers and the clerks, and they cry out and say that please don't do this. It is extremely difficult, because only in Kerala, if you I don't know whether you are aware, the whole country, only in Kerala, there is e-filing in the trial courts. And unless we digitize the entire records, this digital public infrastructure, because these people want what they want is like GPay you can build, like GPay or Beam or something. You file a case number, the entire information is given to them. They just want the litigant to get access to entire records. A lot of privacy issues, etc. are there. But then for a judge, as for the CMS, I can access the entire digitized case. I can look into whichever case I want. The facility is there. But then in a short period of time, if everything goes well, all the district courts and subordinate courts in the state of Kerala will also have exactly the same module.
Fantastic. Just to Mustaque, kind of a final question before we open it up to the audience, your thoughts on that, and possibly also, sir, the one aspect that may have to be also thought through more when we go to the district courts would be the rule changes to support such a radical shift. How do you make sure the rules also support what is being done or can be done?
See that currently we are working on the rules in Kerala High Court. We are almost finalizing certain rules, bringing a new kind of system in place, which would ensure that court is only looking at hearing the cases, not others. That's what we call case manager, would be judicial officer. The rules are being finalized. This idea of case manager came for the reason that, as rightly pointed out to Brother Raja, a judge has to deal with 150, 200 cases on a board a day, and he can't go over the desktop and see it. It's humanly impossible for a judge to work in a paperless court. That's a fact. It is impossible for any judge to work in a paperless court handling more than well, minimum, I would say that minimum could be the 40, maximum could be 40. It is not possible. Because each time you can't look at that file and goes. In paper, quite easy to find out which is the executed result. It is not possible. That realization came, one of the two brothers, Mathew and Justice Gopinath, said, no, it is impossible to work with a paperless code because they are not able to do it. They are able to handle 250 cases a day, and that, not possible. That realization has to think in alternative. Now we are working on the rule. The subcommittee constituted by us, headed by Mrs. Vijayaraghvan and Mia's finalized draft rule for case manager. The idea of case manager is this: the court will devote its time for hearing the cases, finally or interim orders. What my survey showed that out of 5 hours, the productive hours, that means quality time spent by each judge in Kerala High Court is nearly 2.5 to 3 hours. So out of 5 hours, only 2.5 to 3 hours is being spent for hearing the cases. The rest 2 hours is being spent for adjournment, for other steps to be taken, some adjournment, and lawyers are not certain whether matter will be taken up or not. So unnecessarily we are spending time on those. So as such, if this the concept of case management is brought in and is accepted by everyone, there would be reasonable change. Court will list only 30 to 40 cases, may be able to take up. Even court may hear only one case, but quality, we want to ensure that a judge spend quality time for hearing cases. Judge should not engage in other activities, matter to be done by. Of course, that would happen only when entire files are digitized. Central government sanctioned 2,000 crores for the entire nation for digitizing. We will also get a portion of it and we will be doing it. We are in the process of digitizing. Maybe within 6 months or 7 months we will be able to digitize entire work. Then every case will have a calendar and there will be a day. It would be easy for the case manager to manage cases.
Wonderful, wonderful. So, I think that also, because you talked about how digitization has meant that the judge's workload or how they manage the day needs to be different. I think there also needs to be a discussion about how do you think about what this technological intervention has meant in terms of case progress, in terms of disposal times, what it has meant to whom. So sort of an evaluation framework also needs to be thought through, which was not been done in the earlier 2 phases of the e-courts. For this particular, I think it is right time now to also think about what should be an evaluation framework for technological interventions. With that, can I just open it up to the audience? We'll maybe take 3 questions before we wind up for the evening. Is there a mic to go around?
Sorry, so I have a question. You spoke about transferring a lot of this technology in some short order to the lower or the low courts in Kerala. I mean, in hearing the story of how the technological adoption happened in the High Court, it takes time. It takes adoption by various layers of people in the court. But when this technology is then transferred into the lower courts, it's
not transferred. We are just saying that try to do to adopt the CMS, the application.
correct. No, I hear you. I'm sorry I misspoke. But in terms of the spirit of what you said, and I hope I'm getting that question across, it seems like there's a lot of, you need to take a lot of people along with you, right? So it's the lawyers, it's the judges, it's the litigants, and that seems to need a lot of to and fro. So the adoption is going to take time. Is there a plan in terms of the rollout of the system at the lower courts in which how that communication and the adoption can be facilitated or helped? I mean, this is something that we worry a lot about when we think about technology adoption. So I was wondering what your...
Actually, we rolled out the version in the district judiciary. We are using NAC. We had a back-to-back meeting with every bar association in the state, from Trivandrum to Kasaragod. Every day, before the rolling out, I think it's happened in August 1st, we rolled out? August 1st. So we had a meeting with all the bar associations in the state. We got the inputs from them. So whenever they have issues, whenever they lack infrastructure, we provided, whether they feel if they have any technical snag or something, we made a provision to address those issues. We have nodal officers, we have a team to address the grievances. So we made an organizational setup to address, and we also trained many the lawyers and judges as a trainers. So they are imparting training to the lawyers as well as the clerks. So this is an inclusive process, we are not excluded. So even if some requests come from some other bar or some other lawyers, we'll make immediate provision for giving training. And we also devised a program called Join. Judges, I don't remember the expansion. Join is what is the expansion?
Digital Officers e-learning program.
E-learning program. Very structured syllabus. So those, judicial officers will feel that they are not technologically competent. They will be given the training.
You should understand one thing, the e-filing version 1 and 2, which is meant for the subordinate courts to do, they are having that CIS 1 and 2, I guess. Now, the NIC has come up with the e-filing 3 or whatever version. We've imposed upon the trial courts. Now they are using Premier Patani Karana. Ours is an iOS. So the transition will be, because we are incentivizing them by giving a much better thing. That is what we hope. Because they are already into this. They are having the e-filing 3 module, and it is not working the way we want. A lot of small glitches and issues. And we are hoping, because in Kerala, all cases are electronically filed. When they get the CMS, it will be much more, transition will be easy. In the High Court, nothing was there earlier. Now we have set up the entire system. We will interact, our technology people will go there. We've also got the services of the digital university. We got the state government to tell us, persuade them to give technological assistance to us. That only Kerala has. All the High Court don't have a digital university. In Kerala, we have a digital university. So every single thing, I wanted, not important, but then I'm just saying, we got the technologists, you heard him, sandbox and everything, we are not aware of all those things, but then he can come as an assistant, we'll push it through gradually, and we hope that, everything from, ultimately our aim is, OS is filed before the municipal court, appeal before the district court, comes up before the High Court, and goes up to the Supreme Court, a single thread should go on. That is ultimately what we want. Everything will work fine if we had a unified system all over the country, but because it is not happening. But then Kerala is going to go a separate way. We can go back to Karnataka and persuade your judges to set up.
She's from Kerala.
Okay, then you can be with us.
So I have one question. Sorry. Atisha, I'm from Vidhi. We went to the district court today, and like you very rightly pointed out, CIS system is not just very different from CMS, it is extremely difficult to work with as compared to the system that the High Court is using. Despite that, like you mentioned, you have mandated that e-filing is mandatory in district courts as well, in subordinate courts. Firstly, I would like to know the reason for mandating that, despite you knowing that NIC and the system being extremely difficult to work with. So why did you feel the need to even mandate that in the district court? Secondly, this has made scrutiny, as far as we can tell, quite more lengthy in procedure. There are delays that are now occurring which were not occurring in physical filing. So do you foresee that in the near future there would be some sort of a solution, especially to the scrutiny problem, considering CIS is going to be used at least for the next few months, if not the next few years till the CMS system is rolled out?
So if I could just add on one aspect. I'm an advocate practicing in the High Court as well as in the trial court. So I have just
You are a real victim?
Yes, sir. So I just like to point out that as much as the representative from Vidhi has mentioned about the process of filing that becomes difficult, I was there in the trial court yesterday trying to file a wakalat, and I had not taken the help of a clerk. I went ahead and I looked at the videos that were uploaded, and I tried to go through that process to file a wakalat. And that process by which there has to be a litigant account to be created, and then the litigant has to make an offer in terms of the wakalat, and then the advocate has to accept that particular offer, and then there's a connection that is to be made. But I started with this for a while, and later I went to the hub there, the e-hub there. I took their, so the assistant, the person who was assisting, in turn mentioned that, madam, you don't have to bother about the wakalat, the button on the wakalat, you just upload it on the pleadings. So all I did was my wakalat was scanned and I uploaded it on the pleadings end. And then I did go back to the other office wherever it was getting processed, and then it got cleared later on. But I think the whole process was, this is one where the initiation is happening. So I realized that yes, it took me, it is taking a little time, but this initiation is helping in terms of the fact that I knew my document is in and I could actually trace it. So, contrary to the fact that the mandatory aspect of e-filing, I would say that this is where we have to start. Even in terms of the High Court, we had a problem, but in the trial court, this is the only way to go ahead and start doing it. So, as much as I had some hardship in terms of understanding the process and had to go through a different route, that seems to be the only way to start something or to initiate. So I would also just like to remember the fact that I remember hearing Justice Vijayaraghvan in 2019 in Mustaque, one of the evenings when he had come to address the students, and he mentioned how frustrating it was that the e-filing system was not really taking off. And I was just mentioning to Parvati ma'am about it. And today we have come a long way, so I'd like to add that the process is definitely helping many of us lawyers in terms of accessibility and pushing the fact that we are moving the borders ahead. Thank you.
We have the expectation that NAC would improve your version, and we are anticipating that. Loss is not hope. Hope is not lost, or loss is not hope. Maybe we are at this stage, we are looking on in terms of digitization, existing record, and lawyers to be familiarized. We know that a lot of difficulty lawyers experience, but we will have a solution for this in the near future and not pulling out there. You know, the CMS is developed only recently, even tested in the High Court, and we are able to manage it with 5 people here. You just imagine our situation, 5 programmers and another 30% managing it. Judicial is a big institution, and we may not be able to manage the entire infrastructure, right infrastructure across the state, but certainly it is there in our mind. As my brother has pointed out, we're going to start with the LSTD tribunal in Trivandrum. So it would be more helpful to a lawyer can appear from Kasaragod and present this, file his case and argue the case. He need not travel all the way from the Kasaragod to it. The LSTD department already agreed to provide infrastructure. We are in the process of building software. Vigilance already done. We're going to have so many work tribunals. So once we want to see that how that works. Once that is done, then we need to have a supporting staff for this. Now currently we have only ABC people, and those money comes from different. There are a lot of policy issues involved. Something which cannot also divert the things. So we also, sometimes had to adjust to the time, but certainly we will not forget what the trial court lawyers experience. We will come up with a solution, and we have some plan in our mind.
You can check the last page of this brochure. You can see the features that we have in our CMS as well as it is mentioned by them. These our director and all the people out here detailed letters saying that please correct this and everything to the whichever place, KNIC Pune.
So please do download this report. It's available online already. All of you interested, please take a look at it. Congratulations once again, Kerala High Court, for this initiative. Much is done, but like how you rightly pointed out, even more exciting times lie ahead for all of us. More challenges, but more opportunities.
I think whatever area we are working on it currently with the Digital University, we are proposing to enter with the MOU with Digital University. The next stage is with artificial intelligence. So the modality is working on. We had a meeting with Chief Secretary and Digital University Vice Chancellor. So it's currently with the government. One government approves, we'll be working on it, and that will bring a lot of changes. Working and functioning with the code. Of course, it's like, we are not now start using it, machine learning at certain level, base scrutiny, and the next is writ of appeal, soon we'll have. And the committee is also working on the checklist and all. And we are also working along with Bar Association. And Bar Association gives us a lot of inputs. So once that is done, the scrutiny matters the most. Challenging part of the system. Most complaints comes from the lawyers of the scrutiny. So that will be taken care of by machine, and lawyer can only argue with the machine, not with the system.
No, I'm sure you will come up with new innovative ways to handle. But there will always be newer challenges, like how we will always be innovating. So with that, sir, any comments, sir?
This is good enough. Before you leave, I want you to go around to all the high courts and do the same thing and just publish it.
The fact that you've done this is already a vote of this.
Please go back to Karnataka and do this. Now that you've done this, exactly do the same in Karnataka and publish it.
No comments, sir. No comments.
Copy to Suraj and Sanjay Gowda.
Right, sir. Thank you so much. Thank you, everybody. With that, we end this evening's session. Look forward to more such board discussions. Others who are working and looking at Kerala, I'm sure they will also be having such events. Looking forward to participating and meeting again. Good evening.